is now in session. Honorable Paul J. Peruth presiding. You may be seated.
Folks, good afternoon. Okay, I'm here to conduct an arraignment on three individuals. The three individuals are Brandon Kane, Miguel Rodriguez, and Brian Lee. This is all found in case number 128525FY. I do have attorneys here representing both sides of this matter. And Ms. Kettler, would you mind giving the court your appearance, please?
Yes, Your Honor. Molly Kettler on behalf of the people of the state of Michigan, P59877.
Great, thank you. Good afternoon to you. Mr. Reed, your appearance, sir?
Thank you so much, man. Please, this honorable court, Arnold Reed on behalf of Brian C. Lee, P46959.
And thank you. And Ms. Rice, you want to give me your appearance, please?
Yes, may I please the court, Pamela Rice on behalf of Brian C. Lee, P75243.
Welcome to you also. And Mr. Blake, your
Wright Blake appearing on behalf of Brandon Kane, 37259.
all right, great, thank you. So today's the day and time set for an arraignment. Folks, just to let everybody know what an arraignment is is to tell people what charges are, what the possible penalties are, tell them what their rights are, and then to set the matter for a hearing. So I'm going to go through all of the charges contained in the complaints and go through them and advise each of the defendants what the charges are, what the possible penalties are, what their rights are, and then to set the matter for a hearing. We're going to do this by video arraignment, and by video what that means is that the individual defendants are in a police holding cell right now, and we're going to conduct that through video. I do have a smaller TV, and I'm attempting to get a larger one, but there is a TV up there, and we'll be able to watch the arraignment over that TV portion of the process. I've already had some preliminary discussions with all of the attorneys, and the attorneys know exactly the procedure, what we're going to do today, and how this matter is going to be held. A couple of matters that I always address sometimes in very emotionally charged cases. I appreciate everybody coming here today, and thank you all for your coming and your concern in this particular case, for whichever participant or whatever side that you're here for. One of the things that we try to do is act with decorum here in our court, and we try to make sure that everybody acts in an appropriate manner. I always give everybody an opportunity to talk with the court and address it with the court, so I will do that with the attorneys. I am not allowed to address any comments to the members of the public here today, so I'm just going to ask for your cooperation, and please make sure there are no comments, nothing said or anything like that. I do not wish to exclude anybody from the courtroom. I'd rather have everybody included in the courtroom, but at some point if anybody disturbs the court or something to that, I will have to exclude them from the courtroom, and who knows what else may happen. So I just always caution everybody to act with decorum. This is a court of law here in the state of Michigan, and we should act accordingly. Okay, so what I'm going to do then is I'm going to get started. Gentlemen, good afternoon. My name is Judge Peruth, and I'm here to conduct an arraignment of the three individuals. If I could ask each of you to identify yourselves, and I would start maybe with the individual standing on my left-hand side. Sir, can you identify yourself on the record?
Brandon Kane, Miguel Rodriguez, Brian Lee.
Okay. Mr. Rodriguez, there is not an attorney present in court for you, but Mr. Kane and Mr. Lee, I do have two attorneys here for each of you. Mr. Kane, I believe, Mr. Wright Blake, you're representing Mr. Kane?
That's correct, Your Honor.
Okay. And then Mr. Lee is being represented by Mr. Reed.
That's correct, Your Honor.
Okay, so each of the two of you have attorneys here in the courtroom. They're able to see and hear you, and if for some reason you need to speak with them, they will be available for you to comment to. Mr. Rodriguez, you do not have an attorney here. Typically, attorneys are not present at the time of an arraignment. Sometimes they are, but in the majority of cases, attorneys are not present at the time of an arraignment. During the arraignment, at some point, Mr. Rodriguez, I'm going to ask you if you wish to hire your own attorney, or if you cannot afford one, whether you would wish to have a court-appointed attorney. And so at that particular juncture, I'm going to ask you, and then you tell me whether you wish to have a court-appointed attorney or you want to hire your own attorney, and then we can figure out how to proceed with that. Also, the arraignment, gentlemen, is to tell you each of the charges, to tell you what your rights are, to tell you what the possible penalties are, and then to set this matter for a hearing. There was a 10-count complaint that was filed in this court. The first 8 counts of that complaint have been filed against 5 particular defendants: Brandon Lewis Kane, Miguel Valentino Rodriguez, Reginald Vaughn Brown, Jeremy Dwayne Brown, and Brian Christopher Lee. Count 9 is only been charged against 2 individuals. Those 2 individuals are Brandon Kane and Reginald Brown. And then count 10 is only against the first defendant, Brandon Kane. So I'll go through each of those counts and each of the charges and explain what they are. The allegations in count 1 as it relates to all 5 defendants are that they did deliberately, with intent to kill and with premeditation, kill and murder one Ashley Conway. The penalty for that is life imprisonment without parole. Count 2, with respect to all 5 defendants, is that all 5 defendants did deliberately, with intent to kill and with premeditation, kill and murder one Abria Brown. That's also a felony charge punishable by life without parole. Count 3 is called felony murder, and that charge is while in the perpetration or attempted perpetration of torture, that all 5 took part or did murder one Ashley Conway. That's punishable by life in prison without parole. Count 4 is the same felony murder charge as it relates to the deceased Abria Brown. And the allegation is that the 5 defendants, while in perpetration or attempted perpetration of torture, did murder one Abria Brown. Again, that's felony, possible life in prison without parole. Counts 5 and 6 are the same torture charge, and they relate to the 2 deceased victims. Count 5 and 6 claim that with intent to cause cruel or extreme physical or mental pain and suffering, inflict great bodily injury or severe mental pain and suffering upon Ashley Conway, a person within your control or your physical custody. That's punishable by up to life in prison or any number of years. And so there are 2 charges on that for each of the 5 defendants. Count 5 is with respect to the deceased Ashley Conway. Count 6 is with respect to the deceased Abria Brown. Count 7 and count 8 are the same accounts. They're called unlawful imprisonment. And it's with respect to the 2 individuals, and they allegedly, the 5 defendants, did knowingly restrain Ashley Conway and Abria Brown by means of a weapon or dangerous instrument, or did secretly confine and knowingly restrain Ashley Conway or Abria Brown. Those charges of unlawful imprisonment carry with it up to 15 years in prison, a fine of up to $20,000, or a combination of the 2. Those 8 counts are with respect to all 5 defendants, gentlemen. Count 9 deals, as I indicate, is only being charged against the 2 defendants, and the 2 defendants would be Mr. Kane and Mr. Reginald Brown. And the allegation in count 9 is that you did have in your possession a firearm, being a handgun, at the time you committed or attempted to commit any felony charge, either felony murder, torture, or unlawful imprisonment, that you had a weapon in your possession at that time. That is called a felony firearm charge. There's an automatic 2-year prison sentence for that, and that would be consecutive to any number of years in prison as it relates to any other charge. And then count 10 is solely with respect to Brandon Kane, and that is possession of a firearm by a felon. And Mr. Kane, they're alleging that you had at least one prior felony conviction on your record. That felony conviction is for assault with intent to do great bodily harm less than murder. That allegation was that in 2006 you were found guilty of that charge in the Wayne County Circuit Court, and as a result they're claiming that you're not allowed to have a firearm in your possession, and that you did have one in your possession at the time of these particular charges, and there's a penalty for that for up to 5 years in prison, a $5,000 fine, or a combination of the two. So gentlemen, have you heard all of the charges contained against each one of the three of you?
Yes, sir.
Okay, thank you. You all have the same rights. You each have the right to remain silent. The law says that if you give up a right to remain silent, anything you say orally or in writing can be used against you. The law says that you all have a right to have an attorney represent you, and you're entitled to have your each individual attorney represent you. You can have the attorney represent you during any questioning by the police. You can have the attorney represent you during any and all court hearings. As I indicated to you, Mr. Rodriguez, you can hire your own attorney, or if you can't afford one, you can have what's called a court-appointed attorney. Both Mr. Kane and Mr. Lee have their attorneys here in court today. Mr. Rodriguez, how do you wish to proceed? Do you wish to hire an attorney? You can do that. If you can't afford one, you can ask me for a court-appointed attorney, and I would grant that request.
Hire attorney.
Okay. We're scheduled to have a hearing on this case, sir, by April the 19th. So what I'm going to suggest to you, sir, is that you find somebody that you can hire and retain by April the 19th. There's probably going to be 5 attorneys involved in this case, and so sometimes it's very difficult scheduling court cases when there's 5 attorneys, because every attorney's got their own individual courts that they have to be in, and so we'll try and do our best to accommodate all of the attorneys. But the initial hearing is scheduled for April the 19th, which is not this Thursday, it's next Thursday, and that'll take place sharp at 8:30. So Mr. Rodriguez, I would hope if you can contact an attorney and suggest to your attorney that the first hearing is next Thursday, April 19 at 8:30 a.m. Everything we say today, sir, will be given to you on a piece of paper, so you'll know that for your attorney, okay? Okay. Everybody also, the 3 individuals and the 2 individuals that are not here that are also being charged, the law in the state of Michigan says you each have a right to have a hearing on this case, and the hearing will be conducted here in this court, and it must be started within 14 days from today's date. And that's the reason why we have the April 19th day, is that we're going to schedule it for hearing on April the 19th. Mr. Kane and Mr. Rodriguez and Mr. Lee, I've had some discussions with the attorneys and the assistant prosecutor here ahead of time. The issue of bond does not need to be addressed. That's one of the things that I do address here at the court hearing, but I do not need to address the issue of bond because my understanding is that you're all in custody and you also possibly have some parole holds. And so as a result of that, the issuance of asking questions regarding bond probably not be would be mute at this point. And so what my bond would be is that every defendant would be remanded to the custody of the Wayne County Jail without any bond. One of the things, gentlemen, that I tell everybody, and I'm also speaking to everybody in court as well as the 3 of you gentlemen, is that as part of all of my conditions of bond, I always explain to the individuals that there's not to be any contact with any of the victims, any of the witnesses, or anybody having anything to do with it. And so that's direct contact by any of the defendants, or it's indirect contact by any of the friends, family, witnesses, etc., etc. So this court takes it very seriously that there's not to be any contact by anybody on behalf of the defendants with respect to anybody involved in this case. And if the court does hear of anything, then it would have to act appropriately, and I do not wish to be put in that position of having to act. So I'm speaking hopefully loudly and clearly to everybody. Please, no contact between anybody here. Mr. Reed, I typically always ask each of the defendants if they have any questions that they want to ask me at this point. Do you wish me to ask that question to your client, or?
You can ask that of me, I would appreciate it. Your Honor.
Okay, Mr. Reed, do you have any questions on behalf of your client, Mr. Lee?
No, Your Honor, not at this time.
Okay, very well, thank you. And Mr. Blake, Ray Blake, do you have any questions that you wish to ask on behalf of Mr. Kane, or should I ask him any questions?
No, Judge. We don't have any questions, and he doesn't have any.
And he doesn't have any questions. Okay. Mr. Kane and Mr. Lee, each of your attorneys have indicated that they wish to kind of end the hearing here today, not get involved in any discussions with the court at this particular point, and they'll have discussions with me afterwards, but they do not wish to have any further discussions here today on the record. The court's going to remand the two of you to custody then to the Wayne County Jail. Mr. Rodriguez, I'm going to sign an order appointing an attorney to represent you. You're going to hire your own attorney. If for some reason you can't afford an attorney, contact us and we'll get an attorney to appoint you. We'll see everybody here on April the 19th. Ms. Kettler, on behalf of the people, any comments you wish to make?
Your Honor, I have a request of the court, and that is, it's been my experience that quite often people think they can hire an attorney, and that turns out not to be the case. I'm asking the court, because we're anxious to proceed with this exam on time, to appoint an attorney now for Mr. Rodriguez, with the understanding that counsel has to be ready when the other attorneys are ready for our preliminary exam. And if he is able to retain one, that person can take over. But I would hate to see a situation where we couldn't proceed because there was an inability to hire an attorney. And the second issue is, Your Honor, the motion I previously discussed with you regarding our motion to suppress the court file copy of the investigator's report. And I would make that motion now.
Okay, very well. Mr. Rodriguez, were you able to hear the assistant prosecutor? Basically what she's saying is that what she'd like to have me do is appoint an attorney for you right now, because what she's saying is that with 5 attorneys being in court next Thursday, it's sometimes very difficult to get everybody here, and if you come into court next Thursday and say, Judge, I couldn't find an attorney to represent me, then what I would have to do is cancel that hearing date and bring everybody back a couple of weeks after that, and that would just delay the process. I think she makes a good point, and I think what I should do is appoint an attorney for you right now. And if you wish to use that attorney, great, and if you don't wish to use that attorney, that's fine. I'll be more than happy to release that attorney from any service in this case, and you would not be responsible for anything. But at least it would start the process going, and if you didn't have the funds or you couldn't hire somebody by April the 19th, you would actually be represented by somebody in court. Does that make sense to you?
Yes, it makes sense, but I've been contacted with an attorney already. He'll be here.
You've already, are you prepared to tell me who that attorney is, or do you wish to wait on telling me who your attorney might be?
I wish to wait.
Okay, that's fine. Okay. All right, I will handle that. All right, gentlemen, thank you. I am going to grant the assistant prosecutor's motion to take the public information out and not make that part of the public file. I'd be more than happy to do that. Ms. Kettler, anything else on behalf of the people?
No, thank you very much, Your Honor.
You're welcome. Mr. Reed, anything else on behalf of your client?
Nothing on behalf of Mr. King, except we have no objection to the people's second motion with the proviso that we would get what it is we need in terms of relevant discovery issues represented. Subject to that on the record, we have nothing else, Your Honor.
Yes, there was a discussion off the record where the assistant prosecutor indicated that she would present that information to you, and that would make that part of the discovery package, but it would not be public information at this point. And then Mr. Blake, on behalf of your client, Mr. King?
Nothing further, Your Honor.
All right, Mr. Rodriguez, any questions you need to ask the court, sir?
No, sir.
All right, thank you, gentlemen. We'll see everybody on April the 19th.